on. So we are today. Father, I come before you, Lord. I adore you. I respect you, King of Kings, Lord of Lords. As I do this class, be with me. Let the devices work well. The internet, the Zoom, the laptop, and everything. Give me wisdom and knowledge to dispense. We pray God for Nicole. Let her be able, God, to prepare exams well, the exams, and to do in April and pass and be admitted to this year. Give us stamina to continue doing this until the end. We pray all this believing Jesus Christ, our Lord and Savior. Amen. So welcome to April 2024, part 2. Today we are going to tackle question 4, 5, and 6. And as I have said always, that legal writing and drafting is a very practical question. Is a very practical subject. You must practice drafting. Purchasing Q&A and listening to these videos is not enough. You must take a Bible and a book and practice as many drafting as possible. Every kind of drafting that has been tested since 2008 until 2024. Two sittings per year. Those are 34 papers. There is a lot of them. So that you can be able, at least 4 out of 6 questions in any exams are repeated from past papers. You can never go wrong with past papers. So legal writing and drafting, you must practice in drafting. Listening is not enough. Listening can always can only help you on in theory question or reading theory questions, but you must do it practically. So because of time, let me read question 4, which is on your screen. The Republic of Watu Wengi is composed of more than 30 ethnic communities. Majority of these ethnic communities are minorities. In fact, two ethnic communities make up of 60% of the population of the country. As the dominant two communities, a recent study on the employment in the public service revealed that 75% of the employees are men. 90% from two dominant communities, and persons with disability account for less than 1%. A recommendation was made for establishment of an equality commission to be responsible for inclusive in the public service. The Cabinet Secretary for Public Service believes that the current status must be allowed to continue as it is lead to civil strife. This is particularly so because, except for the current Cabinet Secretary responsible for public affairs, a person from ethnic minorities have never held position of influence in government. Consequently, the minister has resolved to embark on developing a legislative proposal of establishment of equality commission. So in exam scenario, not all the facts are relevant. So you underline what is relevant here. So you underline recommendation of an establishment of an equality commission. It is evinced that the equality commission should be a dependent commission with a chief executive officer. So that's also you underline. Further, the commission will have powers on their own motion or filing accompanied by any person to investigate matters touching on inclusivity to the government, summon witnesses, manage the finances, conduct hearings, and make reports on its findings. You underline that. In the event that the commission makes a decision to investigate in order to ensure fair hearing, the commission will be required to give notice of entity intended to investigate. Here, persons expected that and the statement made by person to the commission shall not be used as evidence before court. Underline that. Finally, for the purposes of oversight, the commission will be required to annually submit to Parliament a report on its operation a report on status of employment in public service. Underline that. Without concerning yourself with the wrong title, the enacting formula schedules financial preliminary miscellaneous provisions on investigation, draft the provision establishing a proposed equality commission. Yeah. So this is how you interpret this question for purposes of exams. The question is very clear. You establish a proposed equality commission. So, yeah, and in your exam, you have been told don't do the wrong title. The enacting formula. You know enacting formula, what it is.
Yes.
Nico. Yeah, you
Oh,
know it.
and
Eh?
mwalimu, yes,
Mm-hmm.
yes, and then I don't know if it's a problem from my side, but I can't see what you're projecting.
Okay. No, I had not shared. Now you can see, eh?
Yes, now I can. Thank you.
Yeah, I had not projected. So, you know what as an acting formula is?
Yes, it's the bit that says enacted by the, let's say, Parliament of Kenya as follows. Or if it's a Senate,
Yeah,
it changes.
yes. Correct. You know schedules?
Yes.
Schedules, there are questions that have been tested on a student. You know, you can be taught to draft various parts of a bill. Eh?
Yes.
One of them is schedules, and we are going to look at it when we have finished to November 2024 exams. We are going to go back to 2019 papers and backwards. Eh? So there are questions that have tested students to do on schedules. You know what financial is?
Yes, I want to believe it's a provision that provides for how, like, if it's maybe a bill, how it's going to be implemented and where the resources are going to emanate from to
Yes. You know
enforce it.
preliminary. Yes, correct. You know preliminary what it is?
Yes, I want to believe it's basically the bit on like the short title, the interpretation clause. If you have the objects of the bill, it falls in that same bit.
Correct.
And
So
maybe the bits on the long title.
so in your question, yeah, it is all it is short title interpretation objects. So yeah, in your question you have done short title and interpretation. So that was not necessary. Uh-huh. You know miscellaneous provision.
Yeah, that provides for offenses and penalties.
Yes, yes. Miscellaneous offenses and penalties. And also there is savings and transitional provisions. You can be told to draft savings and provisional transitions. The class you missed last time was asking you to draft something on that. You also need to know how to draft savings and transition provisions. So these are the parts. Eh? So generally, this
Okay.
question wanted you to draft what? To draft the only they are called the substantive provisions. The substantive provisions are the main provisions of the in an exams. The substantive provision are the main cloud, the main drafting in a given bill that establishes what you are drafting about. Eh? So if you are told to draft maybe on Kenya School of Law, so the substantive provision is how you establish the school, the board, and all those kind of things. So the substantive provisions are the one which you are required to draft, and it is the longest in any bill. So that's why the examiner here wanted you to, of course, there is memorandum and memorandum of objects and reasons. After the schedules, you can also that is one also you can also be told to draft on its own. But this question wanted you to limit yourself on substantive provision of establishing a quality commission. So, and because it's the most, they are very substantive provisions. That's why they told you to not to do anything, to do anything on other provisions. So in your answer, so number one is you give the heading. So the Equality Commission Act. After you give that is 1 mark, you jump short title and interpretation. So that one you not be marked because those are preliminary and you are not supposed to draft them. So you go straight to the establishment of the Equality Commission. There is hereby established an independent body to be known as Equality Commission, and you put your marginal notes. The commission shall have perpetual succession and common seat. The commission shall be composed of chief executive and staff necessary for its for commission. Clause 4, the commission shall, these are the function of the commission, promote inclusivity in government, employment, and public service, investigate complaint regarding equality, discrimination, and exclusion, summon witnesses and hold public hearings on the matter, manage its own financial resources independently, and submit reports on its suppression and employment of diversity in the public sector. The commission powers of to conduct investigation. Remember, also the examiner has told you, don't draft on provision of investigation. So in your answer also, that one will not be marked. Powers to conduct investigation, because the question is very clear on that. Are we together?
Yes, we are.
Statement made by witness or complaint before shall be not be admitted as evidence in court. Confidentiality statement. The commission shall submit annual reports to Parliament on its investigation, status of labor diversity, and public recommendation for further legislative and administrative action. So this one you have repeated. You have already talked about submit reports to Parliament on operation and employment in diversity. So this is a repeat. So yeah, if I was to award marks on this, you have done establishment of the commission, which you have done well. Functions of the commission. Yeah. So the most important the clauses that you have drafted well is for purpose of this question is 3, 4, 3 and 4, 3 and 4 only. Yeah. So 3 and 4 only, and this one could not have you could not have allowed you to pass this question. So what was expected of you as the answer? So I look at the National Gender and Equality Commission, which is on your screen. some of the provisions to make it as substantive as possible. So after you do the heading, you go to the sections. So establishments and status of the commission. So these are the some of the factions. See, this is some of the clauses you needed to have included in your answer. So you can choose establishments of the commission, which you have done. Powers of the commission as a body corporate, which you have also done. Guiding principles of the commission, functions of the commission, membership of the commissions, qualification of appointment and chairperson of the members, procedure of appointment of chairpersons, powers of the chairpersons, vacancy of office of the chairperson, removal from office, vacancy, commission, procedures for commission, terms, appointment of secretary. Remember, you don't mix the commission itself and the secretary, which in our scenario they are calling them chief executive officer, and removal of secretary, appointment of staff. So if you go to the substantive now, those are some of the clauses. If you go to section 3, now you explain, you can do 10 clauses to get maximum marks. You establish the commission, which you have done. I don't want to repeat. You have also done, I think you have also done the powers of the commission. No, you have done factions. So, which is yeah, powers of the commission as body corporate, which you have also done. Yeah, headquarters you can put, but no, that's not very necessary. Guiding principles, factions, you have called it factions. Factions of the commission you have done. Now, this is what you missed. Membership of the commission. Every time you are told to establish a commission, because these are very common question in an exam when you are drafting a bill. Membership is very, very important. So who are the members? You put the members, the chairperson and other members. Then the qualification of appointment of members. So they have knowledge, degree, and their qualification. That is section 10 of the National Gender and Equality Commission Act. Then you come to procedure of the appointment. How are they appointed? You explain. Other office you can jump. Tenure of office after they are appointed. How long are going to hold the office? That is an important clause. Then the removal from office. How are they removed from office? So it's the membership, how they are appointed, how they are removed from office, and tenure. Those are important clauses in the commission. Then you come to staff. You can go now to the appointment of the secretary, the CEO. Then removal of the CEO, who is also the secretary to the commission. Then appointment of the staff, which are substantive clause. That is section 21, 22, and 23 of the National Gender and Equality Commissions Act. Yeah. Are we together?
Yes, we are.
Yeah, so you need to improve on that. We are going to do more exercises on that. Any exercise that I'm telling, any weak area we identify, usually note down after we go until after we finish with November 2024. We are going to look at some of these questions in the past papers from 2019 and back, so that you perfect. Are we together?
Yes.
Next question is question 5. Question 5. So a bill in legislative drafting, every question in an exam, you must be asked of a bill. That is the main thing. And if you are not asked a bill in every question paper, you must ask about amendment bill. So it's either a bill or amendment bill or both of them. Those one must is like they are compulsory. So it's very important that someone perfects, and they can come in different facets. You can be told to draft a whole bill. You can be told to draft the areas which we have talked. Like this was asking you to draft an area, which is a substantive provision, or you can be told to draft a whole bill. So question 5, the Intergovernmental Relations Act, Cap 265 establishes Council of County Governors. The Council of Governors consists of governors and 47 counties, whereas the Intergovernmental Act has not established a secretariat of the Council of County Governors. The Council of County Government has always had secretariat responsible for day-to-day administration of affairs of the Council of County Governors. The Council of County Governors is seeking to lobby for anchoring of its secretariat in law. It is you underline that the council is seeking to lobby for anchoring of its secretariat in law. It is believed that they will adequately protect the interests of the staff and boost their morale. The Council of Government responsible of appointing the secretariat want to be responsible for appointing the secretariat. You underline that the secretariat is composed of the secretary and other staff. The secretary shall be the secretary and the accounting officer of the county governors. B, degree holder of at least 6 years experience in administration and employed for 8 years. You underline that. So the provision providing for establishment of council county governors include, so section 19, establishment of council governance, 2021 reports of a council joint committees. You underline that. Your firm have been contracted to advise on the matter. You have determined there is need to amend. You underline that. The Intergovernmental Relations Act so as to actualize the intention of Council of County Governors without concerning yourself with interpretation provisions. So interpretation provisions are usually found in section 2, as well as provision likely to be affected by a proposal. Draft the necessary legislative proposal to provide for the secretariat. So this question is very clear. You amend the Intergovernmental Relations Act to anchor the council, county, the secretariat of council of the council of the county governors. Yeah. So 10 marks. So 10 marks. This is a very, again, like question 5 is a very substantive amendment you are going to do. So it will have many clauses. So after doing your heading, you go straight to the amendment. That's why it is telling you without concerning yourself with interpretation provision and other provisions. So you, after doing your heading, you go direct to your drafting. So let's see your answer. So the heading is correct. The Intergovernmental Relations Amendment Act 2024. So you go to the short title. This act may be cited as the Intergovernmental Relations Amendment Act 2024. Correct? Those are 2 marks. The Principal Act is amended by inserting the following new sections immediately after 19A. Good. So it is insertion. Remember we said there are 3 ways of amending. It is the rating and inserting is the rating thereof. The rating and inserting, the rating completely or inserting. So this one is testing you or inserting a new subsections. So for you, you have chose that you are going to insert yourself establishment of council county government after establishment of council of county government. So that is correct. So it's a section of 19A. They shall be established a secretary of the council of county government which shall be responsible for day-to-day running of the administration of the council. The secretariat shall be composed of a secretary and other staff that may not necessary. Appointment of the secretary. The secretary shall be the county officer of the council, be a degree holder of at least 6 years, be employed at a term of 6 years. Number 2, the cashier shall be appointed by council governors through a competitive recruitment shall serve for terms and conditions defined by the council. The secretary shall be responsible for overseeing the management of secretariat, sheltering implementation of decision made by the council governor, maintaining records of the council proceedings and decision, performing any other function as may be assigned by the council. The council governor shall prepare and submit annual reports and its circumstances to the Senate and National Assembly. So that one, number 4 was not necessary because the question is very specific. Yes, you establish what? The secretariat and the staff. So 4 was not necessary. Even number the transition and implementation. So yeah, so you tried this one. Yeah, you could have gotten marks enabling you to pass more than 5 because you have done the main thing. The only thing you have not talked about so much is the staff. You have talked about only the secretary. Are we together?
Yes, we are.
So I want to share. I want you to look. I want to project on the screen. In fact, this is an amendment that is pending. It was picked directly from this is the Intergovernmental Relations Amendment Bill, Senate Bill, which is pending before Senate. So we are going to go to page 11 of it. You see how you could have perfected your answer. Yeah, so yeah. Yeah, so this is a perfected answer. So establishment of council secretariat. So insertion of new section, you can put on your right as you said, or your left. So establishment of council council secretariat. There shall be a secretary of the council which shall be headed by chief executive. The chief executive shall be completely recruited by the council. A person is qualified for appointment as the chief executive officer and give the qualification. The chief executive officer shall be a county officer. Yeah. The council responsible for council day to day. Without prejudice to the generality, the chief executive shall be responsible for the implementation of decision of the council, the establishment of development of the efficient administration of the secretariat. So that one you have done. Remember, in our previous question, every time you establish an office, you must establish how the person is removed from the office. So this one you missed. Removal from office, how he is removed. The chief executive may remove from the office by the council in accordance with terms and conditions of the service, and you give the reasons: inability to perform, physical or mental incapacity, gross misconduct, incompetence, any other ground that would justify removal. We are together?
Yes, we are.
So every time you establish a commission, you establish the holders of office, you must put how they are removed. That is that is okay. Staff of the council. The council may employ staff unnecessary profile distribution. You do not talk about the staff so much. The staff serving the council shall be commencement of the act shall be deemed to be the staff of the council as provided for other section 23. You did some transition here. Let me see what you did. The service representative for Itagana shall within 6 months of the next of this make regulations of the secretary. Any existing before the event shall continue over office until the secretary is fully constituted. Yeah, so you did well. The transition, you call it the transition. The transition, you call it the transition. Transition of the staff, transition of it and implementation. Yeah. Then remuneration of the staff, you talked about it, and how you are remuneration of the staff. So that was the amendment. You tried that one, you could have passed. So your amendment, you are not that bad. You just need to perfect. And we are going to do more exercises as time allow. Yeah, we are together.
Yes, we are.
So we got to the last question of the day, question 6. The government of Kenya, through the cosmetic regulatory, remember the amendment of bill was tested in the previous paper, even bill. So these are very common questions. You cannot miss them in legislative drafting. So bill and amendment bill, those are like compulsory question in legislative drafting. One or both of them must come in an exam. So it's good when you perfect, you are sure you're of getting good marks in that in drafting. The government of Kenya, through the Cosmetic Regulatory Authority of Kenya, CAR, is responsible for growing rights in an aggregated cosmetic industry and is working towards drafting a registration. This registration is supposed to address the issues of proliferation of substandard and harmful cosmetic products, including their labeling, packing mandate, their registration, and licensing of manufacturers and importers. It is also outline clear enforcement mechanism. Additionally, it seeks to establish robust penal provisions for non-compliance with the law, ensuring accountability and protection of consumers. The law is championed by Cosmetic Regulatory Authority of Kenya. The CAR is thinking of proposing following offences and punishment: manufacture, distribution, and sale of products not approved by CRA, a fine not exceeding 2 million or imprisonment of term not exceeding 5 years. Both imprisonment. If someone intentionally mislabels products, gives misleading provisions on its quality, nature, or safety, will face a penalty of fine not exceeding 5 million or imprisonment of not exceeding 5 years, CRA can also impose both a fine and imprisonment. It is an offense to stop the CRA from doing its work by interfering, hindering, or obstruct CRA in a manner to stop it from doing its businesses. Will face a penalty of fine not exceeding 5 million, imprisonment not exceeding 5 years. CRA can impose both a fine and imprisonment. Draft the penal provisions correctly. So this is 6 marks. You draft the penal provisions. So these are 3, 2 marks for each. Yeah. So you know what penal provisions are, Nicole?
Yes.
What are they?
I think they are provisions that provide for offenses and how to deal with the offenses when it comes to matters penalties.
Yes. So generally, in simple language, this question is testing you on how to draft offenses. And offenses are usually found in, we said they are usually found under what?
The miscellaneous provisions.
Miscellaneous provisions. So yeah, this question is testing you on that. Drafting clauses. That clauses in a bill. So there is this there is a document I'm going to share. Drafting and interpretation of penal provisions by Dima Advocate. Yeah, we are not going to go through it because you know what it is. I'm going to share in the WhatsApp group. You can read later for even answering theory questions. Yeah, so drafting. So how do you draft penal provisions? I
I
want
want
to
to
share.
believe you, fam. You start with
So
you start with the offense.
yeah, so I'm projecting you. I'm projecting. I'm projecting the National Gender and Equality Commission. That is the offense there, section 52. So that is how you draft a penal provisions in the legislative language. So you must use the word a person who without justification of refugee excludes, obstruct, hinders, threatens the commission or member of staff under the act. B, submit false or misleading information. C, fails to honor summons, or you must put or in the last thing. Misrepresent to unknowingly misleads the commission or member of staff of the commission under this act. Commits an offense and is liable on conviction to a fine exceeding 500,000 or imprisonment for a fine not exceeding 2 years or both. So that is one way of drafting a penal provision. So on your answer, a person manufacture, distribution, and sale of unproved products. A person who manufactures, distributes, or sells cosmetic products that has not been approved by CRI commits an offense. Upon conviction, the person shall be liable to a fine of not exceeding 2 million of imprisonment for a term not exceeding 5 years, or both to a fine and imprisonment. So
Sorry, I've not heard you. You're breaking.
yeah, I'm breaking.
I've not heard it. I've not heard what you've said the last as the last
I'm saying,
sentence.
I'm
Mhm.
saying, so I'm saying this is how you do the your answer is that's how you this is not how you do penal provisions, eh?
Okay.
Penal provisions you do how the National Gender Inequality Commissions have drafted, eh?
Okay.
So you say if I was to do, you say a person who A manufactures, now doing the question, manufactures, distributes, manufactures, B distributes, C or C distributes and or C sell products not approved by CRA, uh-huh, commits an offense and is liable on conviction to a fine not exceeding 2 million or both, to a fine not exceeding 2 million or imprisonment or imprisonment you have been told is for what? Imprisonment for a time not exceeding 5 years or to what?
Or both.
Or both. You see how the offenses have been done in the national in the National Gender Equality Commission, eh?
Yes.
So we can even look for another act, eh? I want you
Okay.
to perfect all this. We may not get another question like this, eh? So which act do you
Okay.
think we can look at from your head?
I think the criminal. Oh, sorry, the penal code.
Penal Code, good. So Penal Code, we can look at it. Although Penal Code is a very Penal Code, you know, it was drafted a long time ago. But let's look at it. So yeah, let me share. You see the I want you to perfect on this. So Penal Code is on your screen. So you can use what is projecting on your screen is section 47. So you can use a person or any persons. So when you are doing the different kind of the things, you say A, B, C, and D to set any member to incite. Then you see here down is guilty of the felony as liable to imprisonment. It is any person by name whatever directory. So you differentiate. Then there down you say you give the nini. So penal code is not the best because it was drafted long time ago, eh?
Okay.
Yeah, I don't want to use. Let me look at the Accountant Act. Eh?
Okay.
Accountant Act. Accountant Penal Code is a very long registration. So yeah, I'm opening the nini. Let's go to the offenses. You just look at 2 Act of Parliament. Accountant is most recent. Does that have offenses? Yes, section 41. So if you look at section 41 of the Accountants Act, uh-huh, offenses. Yeah. So share here you see offenses. A person who. So you must put the differentiation. Assumes or uses a title. Assumes uses a title or a or a designatory letters. Assumes uses a title honorary fellow. Others assumes or uses a title of a designatory commit an offense. Uh-huh. So a body corporate, whether incorporated, forcibly use any title. Yeah. So you can establish the offense. And number two, a person who commits the offenses under this section 1 is liable to conviction on the fine not exceeding. So that is another way. Clause 1, you put the offense and the conviction. So looking at your answer, a person who McCharter disputes or says a cosmetic product does not be proved by the CRA commit an offense. So yeah, that is correct one. But two, the language now is where you did not get well. You say a person. So that is the language. A person not upon convictions. A person who commits an offense under one, then you put it as a continuous sentence. Are we together?
Yes, we
You
are.
see how they have done in the yeah. So it's either you do how you put the offense under either in section 1. You can look at section 41, that is 1 and 4 of the Accountant Act, or other way. In another way is how it is done under section 4 of the section 52 of the National Gender Equality Commission. So yeah, a person who you list the manufacturer, distributors, commit an offense. So that's how it's supposed to be done. That's how it's supposed to be done. Hope you have gotten.
Yes, I have.
Yeah, the way you have drafted is not the correct legislative language. And that's why I told you about the legislative language and syntax. Yeah, so penal provisions is how it is in drafted in the Accountants Act, section 41 or 52 of National Gender Equality Commissions Act. Yeah, you need to perfect that. So this is a question that has never been tested before, and that's why I know this is a question that gave student problems. So we got to the last question of the day. You are a student. You are a student. You are a student. You know, part one of your answer, how you drafted, is correct. The only part that was having problem is your two upon conviction. Starting with upon conviction. Two. So yeah, you perfect that. You are a law student completing your prepared at a law firm of Wakili Mkuu Advocates. The firm specializes in intellectual property law. Your people must entrust you in researching and drafting a preliminary legal opinion on the complex copyright infringement case. The case involves a popular musician client A who is accusing a rival musician client B of plagiarism as possession of their melody in a hit song. Discuss the research strategies you employ to identify the relevant legal materials. This includes the following: primary and secondary sources, specific keywords, database, and resources you would use for the research. So these are 4 marks. You give 4 points. This question is usually this are theory question tested at legal drafting, a topic called advanced legal research and legal analysis in Kenya School of Law. So you give 1 point for each. So I want to see your answer. So primary sources and secondary sources, you give, that is 1 mark. Specific keywords, 1 mark. Database, 1 mark. Resources you would use to research, 1 mark. That's how I mark it. So primary and secondary sources, the primary secondary is Copyright Act and relevant case law. International copyright treaties, judicial precedent from Kenya Court. Secondary sources can include intellectual property law textbooks, specific keywords and database. So keywords is limited copyright infringement in music, melody. Keywords you put in quotes: copyright infringement in music, melody infringement, substantial similarity in copyright law. The database will include Kenya Law Report, Westlaw. Resources for research include the law library at the firm, online legal research tools, and music experts. Yeah, you done well that question. This is a question that have not been tested. Let me see if I can answer. I can add something. On primary sources, also you can talk about the Constitution, Article 40 and property law. Yeah. So that one you could have gotten 4 out of 4 marks. You have answered well. You have put what I usually tell you. You differentiate. You put in point form as the examiner wants to see. And that one you have done well. So you have come to the end of today. For part 2. Subscribe to the video, to this video, and the next video is the last paper, November 2024, part 1, which you are going to do at question 1, 2, and 3. God bless you. Take notes and do practice drafting on your own. Listening is not enough.